I'm Gillian Brown. I'm a partner in the private client department at Blackadders Solicitors. I want to talk about powers of attorney, why you should have one, and how to go about putting one in place. I often hear people say that they're too young to have a power of attorney, or that they already have a will, so don't need a power of attorney. There's still a lot of confusion about what power of attorney is and who should have one. So let's bust some myths around powers of attorney. Everyone should consider granting a power of attorney, and unlike your will, which will be used after your death to distribute your estate, your power of attorney is to allow the person you appoint as your attorney to deal with your property, finances and welfare whilst you're still alive. Your attorney's appointment and their ability to deal with those matters ends at the date of your death. Your power of attorney will be used at a future date if you lose capacity to deal with the matters specified in the power of attorney. It is usually intended that your attorney will act at a future date if you lose capacity to manage your own affairs, and whilst you retain capacity to make those decisions for yourself, your attorney is not able to intervene. Many people are concerned that by granting a power of attorney, they're giving up the ability to make the decisions on their own. That's not the case. Your attorney cannot make welfare decisions for you if you retain capacity to make those decisions for yourself. Indeed, if you never lose capacity, your power of attorney may never have to be used. So for example, someone who has a stroke and loses capacity as a result of that, or is living with dementia and at a future date loses capacity, may require their attorney to act at that time. You can appoint as many people as you wish to be your attorney. You can appoint one person initially with substitutes named who can take over if that person cannot act. So this could be a partner with children as substitutes, for example. At Blackadders, we include financial and welfare powers in the one document, but this could be done in separate documents. The attorneys or attorney can be the same for financial and welfare powers, but they don't need to be. It's important to include as many powers as possible in the power of attorney, which you think your attorney may need. These powers should be expressly included if your attorney is to be able to use them. They cannot simply be implied under a general clause stating that your attorney may do anything which you yourself could have done. It's unlikely your attorney will ever use every power under the power of attorney, but when granting the document, it is impossible to know what power they will need. So it's better to include anything which we can reasonably anticipate that the attorney will need. At Blackadders, we're happy to discuss preparing a power of attorney and how the document is brought into effect. Granting a power of attorney gives you peace of mind. Many powers of attorney will never require to be brought into effect, but once they're granted and registered by us with the Office of the Public Guardian, they can be used immediately in the event of the grantor losing capacity.